Hello and welcome back to our YouTube channel. Well, this is the 12th lecture of Indian polity and it is 19th June 2025. Before we'll start our discussion, I would like to give the brief introduction about the initiative which we started from 2nd June. And the name of the initiative is Target IAS 2026, and under this initiative every day we upload two videos. In the first one we discuss the current affairs, which is in the morning session, and in the second one we discuss the static syllabus of yours. So every day we upload these two videos so that we will cover everything what is required for you to clear the exam. In the static part, we had promised you by the month of Jan 2026 we will try to complete your full syllabus, and in this we will try to cover every subject which is required for you to clear the exam, whether it would be related to prelims or whether it would be related to mains. So every subject would be covered except optionals. Except optionals, without optionals we will try to cover everything here. So this is about the initiative. And one more thing I would like to mention, that as we are teaching you here, we are giving you these free lectures, we are making these videos for you guys, but we know that we have the tendencies to make errors. We have this human limit, that we may not contain everything, we may not deliver everything here which is required for you, we may miss many facts. So for that we are making the notes for you guys, in which we will add everything what is required for you, whether it would be related to prelims, whether it would be related to mains. And also I can assure you, after every topic which we will discuss in the notes, they will be followed by the possible prelims as well as mains questions. So these would be very much comprehensive notes for you guys, and if you want to get access to those notes you would have to contact us, and for that you will have to mail us, and you will be told to pay 200 rupees per subject, only 200 rupees per subject. Then only you will get the access to those notes, and those notes would be available once we complete this subject. Once we will complete the Indian polity, then the notes for Indian polity would be available, and trust me, those would be very different notes. What you read, the books which you read, those would be very much different from those books, because when we are making these notes, we are taking into the consideration how an average student or how below average student, what are the problems they face, and we are taking this discussion from the very basic, and also the questions given after every topic, that makes it more understandable. If you want to get access to those notes, please let us know. We'll definitely reply to you guys, and they would be available once we complete the full syllabus of each subject. So this is the initiative what we are dealing right now, what we had started from 2nd June. Now let's start with the discussion. Let's start from where we left yesterday. As we are discussing fundamental rights, we in our previous classes we discussed first right to equality, then we discussed right against exploitation, we discussed right to freedom of religion, and now today we are going to discuss cultural and educational rights. Today we are going to discuss cultural and educational rights, and we will try our best to cover full fundamental rights in today's discussion. So let's have a look at what does Article 29 say. Let's have a look at it and then start our discussion. Here Article 29, it has two clauses. In the clause 1 it says right to conserve distinct language, script or culture. What does it say? The clause states that any section of the citizen residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. This provision is crucial for safeguarding India's rich cultural diversity, allowing different communities to preserve their unique identities. So what does this Article 29 clause 1 say? It is right to conserve distinct language, script or culture. Now let's try to understand it by an example. What does it mean there? What is the background of it? Why this right is given to the people? The India is a very diverse country. There are many fragments of our society, that they have different unique culture, they believe, they have different faith, they have different scripts for that. And you know, the whole idea of India being the union, the whole idea was that this diversity will be conserved. This diversity will be conserved, and this conservation of this diversity of our country, this is highlighted in these articles, in article 29 and article 30. So let us assume, let us see that, you know, there are many tribes in our country, many tribes in our country which have their unique way of marriage. For example, there are tribes where if a man wants to marry a woman, if a man wants to marry a woman, what they will do, what this man will do, by the consent of her parents, he will kidnap this woman, and she will be believed that she is now married to this person. So if we look it on the broader spectrum, if a man from a mainland India, from the general what is the perspective of Indian population, if a man does such this act, it would be considered as kidnapping, it would be considered as raping the woman, and for that there would be very severe punishment for that person. So, but we know that this tribe is following this act from the centuries. You know, we discussed that how tribes, they were actually the before the invasion of Aryans, they were the actual dwellers of this land. And the Aryans, what they did, they forced them to go to these tribes, to go to these forests where they live. So this is the culture which they are following from the centuries. They are following it from the centuries, this culture, and this and they have this belief, they have these scriptures for that. So what constitution says to them, you come with us. What India says to them, what constitution says to them, you come with us, you stay with India, you stay with the united India, and we guarantee you that what are your philosophies, what are your ways, what are your scriptures say, what does your culture say, we will protect them, we will protect them. So this is the protection to them, this is how it is protected. It is this protection is for the minorities. This protection, we need to know that not everyone can say that we have this culture. You know, tomorrow Muslims can stand, they will say that, sir, we have the culture of triple talaq, why you are interfering in us, we have the script for that. For this, you know, we have the, and the fundamental right is article 29, which protects the minorities. So for that we have the answer. This minority, it is not the minority which we believe in. It is not, this minority is not defined here, the minority is not defined here. So this culture is basically for those minority people who have the for those minorities who have the separate culture, who have the separate script, and who have the separate language. It is for those, it is basically for the tribal people. So I hope you had understood it. This is how this is protected. Even though this may seem rape, by this example it may seem rape, but it is not so. And another way, if the same, in the same tribe, if a woman wants to marry a man, now what she will do, she will pack up her clothes, her belongings, and she will go to the man's house and start living there. In the general perspective, it will be called as intrusion. You know, you are entering into my private property. It will not be like it. You know, in general public, we may call the police if somebody enters our private properties. But here the situation is different. It is protected for them. And the second thing, with respect to their divorces, you know, if they want to divorce, for us it should be the mutual, it is mutual understanding that, but for them they just have to cut the leaf and they will be granted divorce. So this is how distinct it is. This is how their scripts are very much distinct. This is how they have the unique culture, they have the unique culture in there. So they speak the unique, they may be having the unique language. This right to conserve it is given by the article 29 of the Indian Constitution by clause A. Then what does the clause B, clause 2 says? Article 29 clause 2 says, no denial of admission to state maintained or aided education institutes on this certain grounds. You know, you cannot be denied of admission to state maintained or aided educational institutes. So here it is very much clear that, you know, in when we discussed, you know, article 28 of the Indian Constitution, and we discussed what are the different institutes. There we saw that there are different kinds of institutes. For example, where you cannot enforce the right to, where you cannot enforce the instructions of religion, or you are not forced to make them worship any particular religion. For example, when it is, government aided, when it is solely government maintained, or when it is aided by the government, the provisions differed there. Then when it is, registered by the government, the provision is recognized by the government, the provision is differed. And when it is private, then the provisions were different. Similarly, in this article also, there is no denial of admission to state maintained or aided education institutes on certain grounds. So in state aided, state maintained, or state aided educational institutes, there is no discrimination. But discrimination can be done on there is, you cannot discriminate except on certain grounds. What are these grounds? Except on the basis of religion, you cannot discriminate. You cannot deny anybody's admission because he belongs to any particular religion. You cannot deny anybody's admission because he belongs to a particular race. You cannot deny anybody's admission because he belongs to a particular caste. You cannot deny anybody's admission because he does not speak your language. So on these basis, you cannot deny admission. But can you deny admission? Yes, you can deny admission. For on what basis? On the basis of age. He might be age appropriate. For example, a 2-year-old kid would want to go to the college. You will deny that. So this is age appropriate. You can deny it on the basis of sex. How is it possible that you can be denied the admission in a college institute on the basis of sex? For example, there is a women's degree college. You will not be allowed to enter that college because it is specific to the woman. There is a specific division for the woman. You have boys degree college, that is for particular to the boys. So this difference can be made by the state. Otherwise, on the basis of religion, race, caste, language, you cannot be discriminated. So this is Article 29. In nutshell, Article 29, it has two clauses. The first one, right to conserve distinct language, script or culture. You have the right to conserve it. And Article 29(2) says no citizen shall be denied admission into any educational institutes mentioned by the state. As here, if it is maintained or aided by the state, then you cannot be denied admission on certain grounds. What are those grounds? It is religion, it is race, it is caste, it is language, or any of them. But can you be denied admission on the basis of your age? Yes. Can you be denied admission on the basis of sex? 100%. Can you be denied the admission on the basis of residence? 100%. So this is Article 29. I hope you had understood it. Very small, very easy to understand. Article 29, it talks about the right to conserve distinct language, script or culture. Very easy to understand. Any section of the citizens residing in the territory of India have a distinct language, script or culture of its own shall have the right to conserve the same. This is what Article 29 says. And by this, we gave the example of tribes, how they have different rules, how they are conserved. In the mainland, it may seem different, but for these minorities, it is different. And also, I would again try to mention here that the minority is not defined here. This minority is not defined here by the Constitution. So please remember that. And the second thing, Article 29(2), it talks about the denial of admission to state maintained or aided educational institutes on certain grounds. What are those grounds? Religion, race, caste, language, or any of them. Can we deny the admission on the basis of on the grounds of age? Correct. On the grounds of sex, 100%. On the grounds of residence, 100%. So this is what Article 29 is about. Now, let's move to the Article 30. Let's move to the Article 30, but first I will try to rub it. So far Article 29 is very much clear. It has two clauses. In the first clause, it restricts, it in a way protects protects the citizens residing in territory of India who have a distinct language, script or culture of its own. They have the right to conserve it. It gives this protection to them. And also Article 29(2), what does it say? That no citizen shall be denied admission into any educational institutes maintained by the state or aided by the state, except on the grounds of what? Religion, race, caste, and on the grounds of religion, race, caste, and language, you cannot deny any admission to anybody, but there may be the other ways in which you can deny this admission. So this is Article 29. I hope you had understood it. Now let's move to Article 30. Let's try to discuss that. What does Article 30 say? Here Article 30 says it deals with right of minorities to establish and administer educational institutes. Who are these minorities? Here, even though it is not clearly defined by the article, but we can assume that these minorities are religious or linguistic minorities. Religious or linguistic minorities. They have this right to conserve, to establish and administer educational institutes. Why this right is given to them? What is the whole philosophy of this right? Why it is given to them? What is the reason for that? If you are a minority institute, if you are an institute in itself, and if this article was not there for you guys, then what will happen that anybody can get admitted in this school. These minorities, if there is an institute in a particular area which is particular to those minorities, and they establish an institute and this article was not there, then in that institute everybody in our country was eligible to get the admission. Anybody can administer that. And if we look at the population ratio, population ratio, when it compared with the mainly general Indians, it was very less for them, and it will dilute their language. It may dilute their religion as well. The significance of their language will get reduced as well as their religion, because they will have to take care of the broader spectrum. The broader idea would be considered, the broader population would be considered. So for them to conserve this, they have this right. This right is given to these minorities to establish and administer such educational institutes for them. So what are the benefits which they get? What are the protections which they get after establishing such institutes? Let's try to discuss them one by one. What kind of protections do they get after establishing such institutions? Let's try to understand that. First, we know that when there is an institute, whether aided by the government or not, for them, whether maintained by the government or aided by the government, for them they have to follow certain rules. If the government will come up with certain rules, they will have to follow that. What are those rules? They will have to give reservation to SCs, they will have to give reservation to STs, they will have to give reservation to OBCs and etc. and economically weaker sections. They will have to give all these reservation to them. But here, if you are a minority institute, there is a one thing which is very much in favor of them, that they are not supposed to give such reservation. They will not be forced to give such reservation. Even though state has made laws with respect to that, but if there is a minority institute, they will not be forced to give such reservation. It is up to them. It is very much up to them. It is not mandatory. It is a voluntary action for them. If they want to give, that is fine. If they don't want to give, that is also fine. So this is the first advantage which they enjoy. And second advantage, which was established by the judgment, namely Saint Stephen's versus the University of Delhi, and the judgment was established that they can give 50% reservation to their community. For example, if there is a Muslim institute, if there is any college which is established by the Muslims, so Muslims in our country, they are minorities. So for them, what they can make laws, they can make rules that 50% reservation in this institute would be for the Muslims only, and they can do it. Otherwise, in other institutes, such rules can't be made. But for them, they can make this rule, and for the rest of the 50, there would be no discrimination. Everybody can get admitted in that institute. So this is another advantage which they enjoy. Then the third advantage which they enjoy here is that once the right to property was abolished as a fundamental right, so there was concern with respect to everyone, that state can come in, they can take anybody's land, and they will not give even a compensation for that, and not even replace that land with another land. So this right is restricted to the minority institutes. First, the protection against compulsory acquisition of right property, this is given to them. This clause was added by the 44th Constitutional Amendment Act of 1978. And what is added here, that if there is a minority institute and state would want to take this take the property of this minority institute, what state will have to do? They will have to give the compensation. Otherwise, state is not forced to give the compensation, but for the minority institutes, they will definitely have to give the compensation. And also, they cannot just take the land here, they cannot just take the property, it should be for the public good. And also, if they are replacing it with some another property, it should be in the same vicinity. They cannot do it. For example, if I have the property, if I am running a if I am running a minority institute, I have a property in Delhi, they cannot take my property there and they will replace it with another property which would be in Kanyakumari, in a village in Kanyakumari. They cannot do it like that, and it should be for the public good, and they will have to give me the compensation. So these are the protections which they get under this. And one more protection which they get, that is, state state usually gives aid to the institutes which are maintained by them. When the state will give aid, they cannot discriminate giving aid with respect to minority institutes. When state will give the aid, they cannot discriminate it with respect to minority institutes. If they are giving aid to the central universities, other universities or other colleges, they will be also forced to give this aid to them. They cannot discriminate on the basis of on the basis that they are the minority institutes. So these are the four advantages which a university or a college gets, or a school gets, when they are the minority institutes. So because of these advantages, there is always a hue and cry from various religious groups or subsects that they should also be given this status, that they are the minorities, they are not the part of the Hinduism, they are different religion. So this is always because of these advantages which they get through. Now, I hope you had understood Article 30 as well. What Article 30 is about? It talks about right of minorities to establish and administer educational institutes. When they administer and establish the educational institutes, then they enjoy certain benefits. What are those benefits? First, the reservation. With respect to reservation, they are not forced to give reservation to SCs, STs, OBCs and EWS. They can reserve 50% of seats for their own community. And also, they cannot be discriminated on in granting aid. Government cannot discriminate them. And also, if the government wants to take their property, they will have to pay the compensation for that. So this is what Article 30 says. Now let's discuss it with an example of the Aligarh Muslim University. Let's try to discuss it, how it has been in news, because it is related to this act. Let's try to discuss that. Aligarh, the issue of Aligarh Muslim University. Aligarh Muslim University. Actually in 1857, when there was the first war of independence, or you can call it whatever you want to call it, whatever your ideology would be. Was it a spy mutiny? Was it only the Muslims who were involved in it? Whatever you want to call it. But on this scale, it was the first time that India has revolted against British Empire. So if we will see who were the most people who were targeted after it, it were the Muslims. Because we have the Bahadur Shah Zafar and various other people who were the part of this, and Muslims were targeted because of this revolt. It was said that it were the kings of that time who, in a way, who rejected the British democratic rule. So it were the Muslims who were mostly targeted. And one of the issue with the Muslims was in our country during that time, one of the major issue that they were very least developed. And why they were very least developed? Because their focus of education, their focus of education was very much concentrated towards the theological theological education. Their focus of education was very much concentrated towards the theological education. And once the rule changed, when the British India came into power, so for that, if you wanted to get the highest offices, you need to have certain there were certain criteria which you need to fulfill. So these Muslims were the people who were least getting benefit of the administration. They were the least developed, and they were the least educated. So for looking this condition of the Muslims, there was a man called Sayyid Ahmad Khan. Sayyid Ahmed Khan, he was very sympathetic towards Muslims, and he was a reformist. His ideologies were different. He thought that the problem with the Muslims right now in India is that they are very much concerned with the theology, with the theological institutes. And for them, it was the time when considering entering into the Christian schools or British schools, it was considered that they are going to convert them. So it was adopted by both Hindus and Muslims as well. So here what he thought that why not, Sir Sayyid Ahmad Khan thought that why not impart the modern education with the theological education? Why not mix them? Why not bring up an institute which will have both educations, which will discuss about the philosophy, which will discuss about the ideologies, which will discuss about the science and technology, which will discuss about the political nature of the society, which will discuss about the governance, which will discuss about democracy, and also at the same time they will discuss the religion, and they will compare the two, and they will see how religion connects with the modern world. So this was the approach taken by the Sir Sayyid Ahmad Khan, and he brought up an institute which was named as Muhammadan Anglo-Oriented College. He made an institute. He brought up an institute, namely Muhammadan Anglo-Oriented College, which further, by the Act of the Parliament, further in 1920 became the Aligarh University by the Act, namely the Aligarh Muslim University Act of 1920. Now the issue was here, after we got the independence, during that time it was this Aligarh University, when we got the independence, during that time it was governed by the Muslims. There we have the Muslim University Court. It was Muslim University Court was there, which contained the only Muslims were the part of it, only Muslims, and they would govern it, they would administer it. But in 1965, the constitution, about Aligarh Muslim University, it is one of the universities which is also mentioned in the constitution. In 1965, it was amended. The Aligarh Muslim University Act 1920 was amended, and the powers of the university court were reduced. What were the powers? It had earlier the administrative role. Now it was reduced to the what? It was only reduced to advisory role. The university court had now only advisory duty. Earlier it has the administrative duty. Now it has the only advisory duty. And another thing which was added, that non-Muslims can also be part of the university court. So this was an issue. But here we have the Article 30. What does Article 30 say? Article 30 says that a right of a minority to establish and administer education institute. Sir, we have this minority education institute. We have Aligarh Institute. It is established by Muslims. It was established by Sir Sayyid Ahmad Khan, and now the government is interfering with us. What does they say? That government is interfering with us, and they are trying to change the nature of this institute. So what they did, they went to the Supreme Court. And when they went to the Supreme Court, and the case was named as Aziz Pasha versus Union of India, 1968. And this was a landmark judgment, which and what were the points highlighted in it? It has changed the definition of the institute, the educational institutes, the minority institutes. So what was adopted under this? In this judgment, Supreme Court said that it is not a minority institute. Why it is not a minority institute? Because it was established This Aligarh Muslim University, it was established by the Aligarh Muslim University Act of 1920, established by the Act of a Parliament. By the Act of a Parliament. If anything is established by the Act of the Parliament, at that time it was the British government. If they had established it, then it was for everyone. So when the government is not for the particular section of the society, government is for everyone. So how is it a Muslim minority institute? So when the in the Aziz Pasha case, when the Supreme Court said that it is not a minority institute because it was established by the 1920 Act, so it is not a minority institute. And what the government has done here, they have done right. They can change the they can change the nature of the university code. It was earlier it had the earlier it had the administrative job. Now it has just an advisory job. They can do it, and also they can add non-Muslims to it because it is not a minority institute. So this case went further. In 1981, when there was there was Congress government, and one thing about Congress government, and they are blamed for that. They had always tried to win the favor of Muslims. So what they did, they brought up an amendment to this 1920 Act of the Aligarh Muslim University 1920 Act in 1981. And they said that this Muslim University Act, this Aligarh Muslim University, it is an, in this they said that it is a minority institute. So they established it by the 1981. In the 1981 Parliament amended the 1920 Act and established that it is a minority institute. So once this minority institute status was given to the Muslim University, to the Aligarh Muslim University in 2005. In 2005, what they decided? In 2005, they decided that they will give reservation up to 50% reservation for Muslims in PG Medical College. So they decided that in 2005, that once in 1981 it was decided by the Parliament, the Act was amended, the 1920 Act was amended, and it was added that this institute is a minority institute. Now in 2005, the Aligarh Muslim University, they decided that they will give reservation, 50% reservation for Muslims in PG medical courses. So the case went to the Allahabad High Court, and Allahabad High Court said that it is very much unconstitutional. Aligarh Muslim University cannot come up with such reservation policy, and also it said that the amendment which was made in 1981, that is also unconstitutional. And the Allahabad High Court also added that we are still following the Aziz Pasha judgment in 1968. So this was established in 2005. In 2005, let me repeat again, in 2005, the Aligarh Muslim University, they decided to give the 50% reservation to the Muslims in the PG medical courses, but the case went to the Allahabad High Court, and Allahabad High Court struck it down, said that it is very much unconstitutional, and the amendment which was made in 1981 with respect to the Aligarh Muslim University Act of 1920 is also unconstitutional, because we believe in the Aziz Pasha judgment. So after that, there was hue and cry over this issue. There was huge hue and cry whether it is a minority institute, whether it is not a minority institute, what are the criteria for an institute to be a minority institute. So many things, there were many discussions, because there are various colleges in our country on which we have to decide, on which the Supreme Court has to decide whether they are minority institutes or not. So what did Supreme Court did in 2019? They did that, they acted very beautifully, that in 2019 they decided that they are going to set up a 7 judge bench, and it will decide what are the provisions, what should be the provisions of an institute to be a minority institute. It decided over it. And what were the provisions established here? What were the provisions established? First, it was to be seen what is the purpose of the institute. when it was established, what was the purpose of the institute? If we look at, if we will ask Sayyid Ahmad Khan, Sir Sayyid Ahmad Khan, sir, you had brought up this Anglo Mohammedan Institute, Mohammedan Anglo Institute, what is the purpose of this? So he would say us that his purpose was to educate, to uplift the people, the Muslim people in our country. So his purpose was very much categoric. It was to uplift the people. Then the second question, which the courts will ask, to make an institute, to give, which the parliament should ask, which the courts should ask, whether it is whether to decide on whether an institute is a minority institute or not. The second question is, what was the true origin of this institute? What was the true origin of this institute? When this institute was introduced, for example, I will give you an example. There are Nalanda University or another university. Suppose if today we are going to convert the future of that institute into some Muslim university, is that possible? The courts will say that let's have a look, even though we have the different acts with respect that we discussed that, but still the court will say let's have a look at it. What was the future of it before the independence? I don't know what was the true origin of it. What is the true origin of Aligarh Muslim University or Anglo Mohammedan University? What is the true origin of it? The true origin was that it was a minority institute. It was for the welfare of the people, welfare of the Muslims. Then the third thing, what the court will ask, who implemented the idea? Who implemented the idea? Suppose I will have the idea that I am going to make a college for Muslims. I have this idea and I share it with my friend, and he belongs to any particular other religion. I don't have the money to invest. What he does, he has the money, he has the power. He established an institute and he named it as a Hindu college, university, or whatever he names it. So I will go to the court, sir, it was my idea and he stole it he stole it from me. This institute should be given the minority status. The court will slap me. They will say that it is not you who brought this, you who established it. It is this person who is implementing the idea. So it is what his ideology was. This will work, not your ideology, what you thought. You did not implement it. So that's why it is important who implemented this idea, who supported the funding of this idea, who gave the land for this institute. So this is to be looked into. Then the fourth thing which they have to decide. What is the fourth thing they have to decide? What was the nature of the institute before the constitution came into existence? Before or we can say before independence, what was the nature of the institute? Who was the governing body of the institute? And we know that for the Aligarh University, the governing body was University Court. And what was the states? It was not advisory. It has the full power to administrate the university. So definitely its nature was different. So now if these are fulfilled, then only an institute can be given the status of the minority institute. Now you can ask me a question, sir, now presently what is the status of Aligarh Muslim University? To which I will answer, it seems that it is a Muslim university, it is a minority university, but there is yet we cannot say so. Why we cannot say so? Because after giving this judgment, the courts decided that after this 3-judge bench will listen this case and they will decide on these parameters which we had highlighted here, and then they will give the judgment whether the Aligarh Muslim University is a minority institute or not. So far right now we don't know what is the status. Once the 3-judge bench will hear the case, they will decide on these parameters. After that they will give the judgment. So this is about the minority institute. If you have the minority, if you are minorities, you can have your own institute and you have certain provisions for that which you enjoy. This is what Article 30 says. This is what Article 30 is about, right of minorities to establish and administer education institutes. Once they have the education institutes, they enjoy certain powers. For example, they are not forced to give the reservation to SCs, STs, economically weaker sections or OBCs. Second, their property cannot be acquired forcefully by the state. If state does so, there should be a public reason for that. And also state has to give the compensation, and while giving the grants, while giving the aid, aid by the state, state cannot discriminate on them. So these are few things which they enjoy. So with this, I hope you had understood this article also. Now, ideally we should have been discussing article 31, but this we will discuss when we will start the DPSPs, because there is definitely the connection with the DPSPs that we will discuss. Article 31A, 31B, 31A, 31B and 31C. We will discuss it there when we will compare the fundamental rights with the DPSPs. So let's move to the article 32. Let's move to the article 32. Let me first rub it, then we will discuss that. Now let's try to discuss article 32. Let me change the pen here. Yeah. Now let's assume a condition. Suppose you have a right to equality. You have article 14, 15, 16, whatever, 17, 18. You have 19. You have right to, you cannot be exploited. You have article 20, 21, 22. You have right to freedom of religion. You have right to freedom of religion. You have everything. But one thing you don't have, that is you don't have article 32. What is this article 32? Suppose if state restricts these rights, they are giving you the rights. Suppose state is giving you the right to live with liberty, right to live with liberty. You have this everything. You have the right to freedom of religion. You have right to speak as ever what you want to speak. You have right to form an organization. Everything is given to you. But one day what state does, they are just promising you these things, but they are not implementing these things. Even though this right is there, it is in the constitution, but they are restricting these rights to you. They are arresting you without any reason. They are restricting the article 19 without any reason. They are hanging people under article 21 without any reason. And the law here is that you cannot go to the court. Article 32 is not there. So even if you have the right, if you have these rights, but you don't have this article 32, this would be nothing. Their importance would be nothing. It would be like you don't have any right, because without article 32 you cannot have these rights. This article 32, it is considered fundamental to fundamental rights. Article 32 is the fundamental to fundamental rights. And as as B.R. Ambedkar said, that article 32 is the fundamental to fundamental rights. And article 32 itself, it is the remedy, and it itself is the fundamental right. This is the beauty of article 32. Now let's have a look at why it is so important, why there is so much buzz around it. Let's have a look at the discussion behind it. Let's have a look what this article 32 says, what it is about. Here article 32, what does it guarantee you? It guarantees right to move the Supreme Court, under article 32. Here is a thing. For example, if your fundamental right is violated, by the state or by anyone, what you are supposed to do, where you have to go? You can go to the lower courts, you can go to the higher court, you can directly go to the Supreme Court. This is one of the guarantee given to the fundamental rights. If it is violated, you can directly go to the Supreme Court. So this is one of the guaranteed right to move to the Supreme Court. Now suppose a legal right is restricted. For example, you wanted to vote or you want to marry, and you are not allowed to marry, for certain reason. Can you go to the Supreme Court? Earlier it was established that right to marry is a fundamental right, but in 2024 we saw that how it is not a fundamental right anymore. So for this reason you cannot go to the Supreme Court directly. You will first approach High Court. Or the lower court. So this is the difference. With this Article 32, it guarantees you that if any right which is given in Part 3 of the Indian Constitution is restricted to you, you can directly approach to the higher authority, that is Supreme Court. You can directly go to the Supreme Court. Once you will go to the Supreme Court, what Supreme Court will do? Supreme Court powers, it powers the Supreme Court to issue writs. So it powers Supreme Court to issue writs. Now let us discuss what are these, what kind of writs are they, what are these writs. So for that, let's discuss them one by one, but let me rub it first. Let's discuss these writs one by one. Very often in the prelims exams, a question about a writ, you will see after 1 or 2 years, there will be a question about a writ. So it is very important for your preparation to understand it, and it is often confusing. So let me make it very much clear for you guys here, so that once you will watch this video, you should never forget it. So let's see what are these writs given by which are given to this, which Supreme Court can give. 1. Habeas corpus. It is the first writ. What is this writ? For example, you have a friend or anybody. Suppose let's take an example. You have a friend and he is arrested by the police. And you approach police. Why you arrested him? Police says that we had not arrested him. What are you saying? You tell them we saw that you arrested him. The police will say no, we had not arrested him. Now what is your where you can go? You can go to the lower courts, you can go to the High Court, and you can go to the Supreme Court. Where would you prefer to go? If he is very dear friend to you, you will definitely jump to the Supreme Court, and you will ask the judiciary there, Supreme Court, sir, judge, sir, please issue the writ of habeas corpus. Please issue the writ of habeas corpus. What is this writ? This in simpler terms means bring the body. So here, or to have the body, bring the body, or to have the body. So the Supreme Court will issue this writ to the police. Once you will approach this Supreme Court, when police will hear that he is approaching Supreme Court for habeas corpus, and they know that they had detained this person illegally, they will leave him before you approach the Supreme Court, before the Supreme Court issues this habeas corpus writ. Suppose the Supreme Court issued this habeas corpus writ. Once it issued the habeas corpus writ, now they will ask police to bring in this person which you had arrested. Police will bring this person. Why you had been arrested? Sir, I was arrested for no reason. They did not give me any reason why I had been arrested. The Supreme Court will tell you, nobody can arrest you now. The Supreme Court will let you free, and the police who had arrested you, he will be prosecuted by the Supreme Court. So this is the habeas corpus. Now here is another concept which you have to understand, which is locus standi. What is this locus standi? Does it apply to the habeas corpus? As I told you, once you will understand this term, I personally believe the most important article in the fundamental rights is the Article 32, because from this article most of the times you will see a question in the prelims exam. In 2024 a question about mandamus was asked. Before that many questions were asked. Rest of the articles, they are easy to understand, but this article, it is little bit confusing. Now what is this locus standi? Coming back to our discussion, this locus standi, suppose you complained about your friend. Now there was another person who was kidnapped, and you approached Supreme Court. Sir, a particular person has been kidnapped by the police. Please bring that person. Please issue the writ of habeas corpus. The Supreme Court will not ask you who are you to that person, because this locus standi if it would have been there, then the Supreme Court will tell you, are you related to that person? You will say, no sir, I'm not related. Then Supreme Court would have told you to get away from here, because locus standi applies here. But with respect to habeas corpus, locus standi does not apply. That even if you are not related to that person, even if you are not related to the case, you can still file it, you can still ask for the writ. So locus standi does not apply. Now it is about the police authority. Now tomorrow, for example, you are in love with a girl and you belong to a particular caste, she belongs to another caste, and you want to marry her. And when you were about to marry, her parents came in and they kidnapped her, they forced her to, they locked her in their home. Now you are a boy, what you will do, you will go to the Supreme Court and you will ask Supreme Court, sir, please issue the habeas corpus writ against for her, for the search for this girl against her father. The Supreme Court will tell you why we have to issue this habeas corpus writ. You will say, the Supreme Court, sir, I was about to get married to this girl, her parent kidnapped her. So the Supreme Court will tell the police that please bring this girl to us, and we will ask this girl whether she was kidnapped by her father or not. Then when the police will bring this girl to Supreme Court, then it is up to the girl whether she was loyal to her boyfriend or not. That is some different story. But the point why I gave this example here, that this habeas corpus writ, it applies to both to state as well as private individual. So it applies to everybody. This is the writ of habeas corpus. I hope you had understood it. Now with this, let's move to the another writ, which is the writ of mandamus. Let's try to understand that. Writ of mandamus. First, let me rub it. So why we are discussing these writs? Because it is the Supreme Court. If fundamental rights are violated, we can go to the Supreme Court and ask for the remedies. And these are the ways by which Supreme Court can give us the remedies. Now let us discuss the mandamus. What is this? What is this mandamus? Mandamus. Now what is this writ? For example, there is a public body. Take an example of the municipality. You have the locality. In your locality, outside your home, there is huge garbage and they are not cleaning it. You are going to the municipality that, sir, please clean this garbage. It violates my environment, which I have the fundamental right to have the clean environment. I have noise pollution here, I have the air pollution near my house, I'm not able to breathe properly, please remove it. The municipality says you that please give us some money, then only we will do it. So what you will do, you will go to the Supreme Court and tell Supreme Court, sir, please issue this writ of mandamus. What this writ would be, once this writ of mandamus would be issued, if they are not doing their duty, the Supreme Court will issue this writ to the public authority. They will ask municipality why you are not doing this, and they will force them to do it. So this writ of mandamus, it is issued against the public authority for not doing their duty. Writ of mandamus. About writ of mandamus, again, does locus standi apply? Does locus standi apply to the writ of mandamus? To the writ of habeas corpus, locus standi does not apply. To the writ of mandamus, does locus standi apply? No. Yes, locus standi applies to the writ of mandamus. You know why? Because let's take another example. You are living in Delhi and your friend is living in Kashmir, suppose, and outside your friend who is living in Kashmir, outside his house, there is the same issue. Now he is not approaching to the court. You are approaching on his behalf that, sir, my friend, he is living in Kashmir. The municipality is not working there properly. They are not cleaning the garbage there. So please issue the writ of mandamus against them. The Supreme Court will slap you and Supreme Court will tell you, get the hell out of here. Don't waste our time. If your friend has the problem, he will come. If you are not involved in this case directly. So this is the locus standi. It does apply in the writ of mandamus. And writ of mandamus, it is issued against the public body. It is issued against the public body who is not doing its duty properly. Now the third writ. Third writ, one is prohibition and another is certiorari. Prohibition and certiorari. What is this prohibition? For example, there is a tribunal which is the quasi-judicial body, and whose major focus was to reduce the case burden on ordinary courts. So they are hearing your case. Once they were hearing your case, or lower judiciary is hearing your case, or high court is hearing your case, and they are not doing justice with you, they are not letting you speak enough, they are not letting your advocates speak enough, and they are taking only one side of the judgment. So what you will do, you will go to the Supreme Court and you will ask the Supreme Court, sir, my case is in the tribunal, is in particular tribunal, or in particular high court, or in particular court, and they are doing very much bias with respect to me. So please issue the writ of prohibition that prohibit them from continuing this case from where this case has reached right now. Stop them doing this, stop them judging this case, and rather what they will do, they will transfer this case to any other judge or any other court, or you take the custody of the case, but don't let them continue on the case. So this writ is called the writ of prohibition. And for the writ of prohibition, what does locus standi apply? 100% it applies. What is certiorari or certiorari, whatever you can pronounce it as, it is same issue, but here the case is finalized, the judgment is given, but you are not satisfied, so you will go to the Supreme Court and issue that, tell them that to nullify the judgment that they had violated my basic natural law, they had natural rights, they had violated my natural rights, so please nullify the judgment, and this would be done under the certiorari. And these both prohibition and certiorari or certiorari, it is given against the lower judiciary or the tribunals. So both quasi whoever there is organization who has the judicial nature, it is given against them. So this is about prohibition and certiorari. Now the last writ which is particular to the Supreme Court, it is quo warranto. The last writ under Article 32, which is the power of the Supreme Court, the remedy given to us, the writ, it is quo warranto. Quo warranto. For example, what is this? Suppose tomorrow anybody gets appointed as IAS officer, and you have an issue with it. Why? Because you know that that particular person who is IAS officer in your district, he has not even cleared the prelims exam. You will approach to the Supreme Court and you will tell Supreme Court to give this writ of quo warranto, on which authority he has been appointed, from where he gets this power to issue this writ, and ask them to come in and they will give the answer whether he is right or not. So this quo warranto, it asks the question, what is the authority through which he has been appointed? This writ, it is also for the public body, Suppose now I am the CEO of Salvation IAS. Suppose I make it a big brand. Now I am the CEO of Salvation IAS. You cannot go to the court and ask a court to issue this writ of quo warranto against me, because I am a private body. So this quo warranto, it asks what is your qualification. If you are qualified, then it is fine. It questions your qualification, why you are there. So this quo warranto is issued. Now a question can come to your mind, sir, I am not happy with Amit Shah, or Amit Shah being the Home Minister. Please issue the writ of quo warranto against him. To which the Supreme Court will tell you, what is the criteria for any person to be the minister? Either he should be the part of the parliament. He should be the part of the legislature, and if he is not the part of the legislature, he is elected from the outside, then he should contest the election. This is the qualification. Whether he is capable of doing his job or not, that is something different. But what is the qualification? The qualification is checked under the Q warrant, on what authority you are there. The qualification is that he is the member of the parliament, he is the member of the Lok Sabha. Definitely he was elected by the people, he has the authority to, he has the capability, he has the qualification to become the home minister. So this writ cannot be issued against them, but it can be issued against the people, public body who is being appointed, the government body who is being appointed. We can issue this writ for that. So this is about the Q warrant. These are the writs which are given to the Supreme Court. Now what is the third? This is what the Article 32(1) says. It guarantees right to move to the Supreme Court. Article 32 clause 2 says Supreme Court's power to issue writs. We discussed these writs. I hope they are very much clear. Article 32 clause 3 says Parliament's power to empower other courts. Parliament can empower other courts with respect to certain powers that you have. You can take a particular cases, or they can empower the tribunals for that. That is okay. And Article 32 clause 4, no suspension of the right. These are given under Article 32. So this is what Article 32 is about. Now with this, I hope you had understood it. You had understood Article 29 also, Article 30 also, Article 32 also. About 31 clause A, B and C we are going to discuss when we will take up the DPSPs, because we will have to compare them with DPSPs. We will discuss that there. Now let's move to the Article 33. Let's see what does Article 33 say. Article 33 says power of a parliament to modify the rights under Part 3. Article 33, it gives the power to the parliament. Here please note down that power to the parliament to modify or restrict the rights given in Part 3. These fundamental rights, it can restrict it, it can modify it for particular people. But this power is given to whom? Please remember that it is given to the parliament. A prelims question may be asked to you that state legislature is given this power to restrict these particular powers, these to modify the fundamental rights. No, that would be incorrect. It is the parliament which is given this right. Now what are to whom they can restrict it? Let's discuss them by reading the article. Very simple article. Let's see. Article 35 specifically mentions the following categories of people whose fundamental rights can be restricted or abrogated by the parliament. First, members of the armed forces. You would have heard about that Jawan who made a video about their kitchen, how they are not treated well, and what happened to him? He was restricted, he was dismissed from his job, even though he was enjoying the right to freedom of speech and expression, but still he was removed. And what was the reason for that? Because this right to freedom of speech and expression, it is restricted for certain kind of people. These fundamental rights are restricted by the parliament for certain kind of people, and one among them is the members of the armed forces. This includes the army, navy, air force and other auxiliary forces. So this is what who are restricted. Then the another members of the forces charged with the maintenance of the public order. This primarily refers to the police forces and parliamentary forces like CRPF, BSF, ITBP and etc. They are also forced to remain quiet about it. They cannot say anything about it, and their rights are restricted by the parliament. And what are the other people? Persons employed in any bureau or other organizations established by the state for the purpose of intelligence. These spies, those spies, this is restricted for them. They cannot enjoy their fundamental rights fully. So this is very much restricted for them. And fourth classification is persons employed in or in connection with the telecommunication system, who are in the telecommunication system, but they are associated with these three categories. For them also these fundamental rights are restricted. So who are the members? Members of the armed forces, members of the forces charged with the maintenance of public order, persons employed in any bureau or other organization established by the state for the purpose of intelligence or counter intelligence, and persons employed in or in connection with the telecommunication system set up for the purposes of any force, bureau, or organization referred to in clause A to C that we discussed. So for them, the parliament has the power to restrict it. Can a state legislature restrict this power? No, they cannot restrict it. Now let's move to the another article, article 33. I guess it is very much clear now. Now let's move to the, now here with respect to this, can here I would want to add one more point, that you would have often heard that there is a uh, uh, you know workers union, laborers union, and they have their association, they have their tilt for particular political party or other political party. But have you ever heard that there is an association in army or forces or intelligence? You would never hear that, because this, to form an association, to form a corporation, it is restricted for them. So similarly, this is what article 33 says. Now let's move to the article 34. Article 34, it provides for the restriction of fundamental rights while martial law is in force in any area within the territory of India. It also validates acts done during the martial law and indemnifies persons for such acts. Now, this article 34, it talks about the martial law. But what is this martial law? Is it defined by the constitution? No, it is not defined by the constitution. But what we assume it is, suppose in a state or in our country, throughout our country, our forces had failed, the political authorities had failed, the executive has failed to curb the tensions. Now what is left? It is the army which is left. Now the army may come in and they will curb these tensions. They can curb these tensions. They would come in and they will resort to solving the issues in the region, and it is called the, it is assumed that it is the martial law. And when this martial law is there, we know one thing, that when how police, usually the administration, this enforcement of law, it is given to the police, because they are trained differently. They know how to control their anger, they know how to control the people. First they will use lathi charge, they can spray water, they can go for the tear gases, they can go for the rubber bullets, all that they will do other stuff. But the army, they are trained differently. What army will do, they only know how to kill. And when there is martial law, and when they have the situation to handle the situation in a particular country, in our country, what they may, there may be many army men who cannot control their anger, who cannot control the situation. They may use the bullets too. They may corrupt the fundamental rights of the people. They may kill certain people, and they may be innocent. These people may be innocent. Once this martial law will be over, such people who had killed these people, these innocent people, they will not be asked the question why you had done this. So this article 34, it gives this protection to these army men. It gives them this power that they can do it. But does the article 34 define the martial law? No, it does not define martial law. What is martial law? It is not defined here. Now, one more thing. This is in a nutshell what martial law is about. We usually had a beautiful, not beautiful, so beautiful, but very friendly country. I'm sarcastically saying it. We have Pakistan. From from independence, from the bifurcation of India and Pakistan, most of the times we had seen there is the martial law there. And what kind of martial law is there? The suddenly the army will decide that the government, the democratic government who had been elected by the people, it is not working properly. They will come in and they will get the authorities in their hand. And they had done it many times. In 1999, when the Musharraf imposed martial law, how he did it. I hope this kind of martial law is not what it is. It is not imposed. It is not never imposed in our country. So what basically Article 34 is talking about, that when there is martial law, these are certain rights which they enjoy, and certain fundamental rights are restricted. So with this, Article 34 is clear. Now let's move to the Article 35, the last article. It says legislation to give effect to the provisions of the part. This article empowers Parliament to make laws to give effect to these certain specified fundamental rights and to prescribe punishment to acts declared to be offensive under Part 3 of the Constitution. It also restricts the power of the state legislature in certain matters related to fundamental right. So, in nutshell, what does Article 35 say? That we have different articles. We have Article 21A, under which right to education was made the fundamental right, and for that we have the Right to Education Act. And who can make this Right to Education Act? It is the can the state government come up with this act? For if there is fundamental right, in getting the effect of the fundamental right, you need some act, some state legislature, you need some act for that, you need some law. Can state make that law? No, state cannot make that law. State cannot make the law to give the effect to the fundamental right. It is the parliament who has the right to make the law which will give effect to the fundamental right. This is exactly what this Article 35 says. So with this, we had completed the fundamental rights. I hope you had understood it. Very simple, very simply I had explained all these things. If there is any confusion, please do write in the comments. We'll try our best to clear that. From tomorrow, we are going to discuss the directive principles of state policies, PPSPs, and we are going to discuss them in detail. Tomorrow's lecture is going to be a little big because we will try to complete the DPSPs in full detail, and after that we will take up the fundamental duties. So with this, I hope you had understood it. Now one thing which I want to compare here is Article 32 and Article 226. It is for the high courts, it is for the Supreme Court. Both issue writs, but for the high court it has the wider scope. Even if the legal right is restricted, you can approach the high court. If the fundamental right is restricted, you can approach the high court. But for here, only the fundamental rights, it deals with only fundamental rights. This is about Article 32, and this is the difference between the two. Now coming to the last, let's try to solve the question here. The question says, consider the following statements regarding Article 25 of the Indian Constitution. First statement, it guarantees the freedom of conscience and the right to freely profess, practice and propagate religions to all persons including non-citizens. Correct. Second, the right to propagate religion under Article 25 includes the right to convert another person to one's own religion by force or inducement. Totally incorrect. We discussed that. Option 2 is incorrect. We can eliminate these two options. Now let's have a look at the option 3. The state can regulate economic, financial, political or other secular activities associated with the religious practice under this act. Article 2. The wearing and carrying of earphones by Sikhs is considered to be included in the profession of the Sikh religion. That is also correct. So with respect to this question, the correct statement is option 1, option 3 and option 4. And from the code given below, the correct code is option B. So with this, we complete today's discussion. I hope you would have liked the video, you would share it with your friends, and I definitely hope you would subscribe the channel. Thank you for staying with us. Thank you very much and have a nice day.